Good morning, everyone. I would like to welcome you to Assembly Judiciary Committee. Welcome to everyone here in Carson City, as well as those in Las Vegas, and anyone watching online through Nellis or our legislative YouTube station. With that, Secretary, will you please take the roll?
Assemblywoman Bilbray Axelrod. Here. Assemblywoman Cohen. Here. Assemblywoman Considine. Present. Assemblywoman Gallant. Here. Assemblyman Gray. Here. Assemblywoman Hanson. Here. Assemblywoman Hardy. Here. Assemblywoman LaRue Hatch. Here. Assemblywoman Marzola. Here. Assemblywoman Mosca. Here. Assemblywoman Newby. Here. Assemblyman Orentlicker. Here. Assemblywoman Summers Armstrong. Present. Assemblyman Urick. Here. Chair Miller.
Here. And with that, it appears that all members are present. So just a few housekeeping reminders. Please turn off anything that has an alarm or a ringtone that could make noise and be disruptive during the hearing. Again, this meeting and information about it is stated on the agenda on Nellis, as well as you can watch it through the legislature's YouTube. We will have public comment at the end of the meeting, and our meeting today consists of one presentation and 2 bill hearings. So our first presentation, we have a presentation from the Public Defender's Office with Chief Deputy Public Defender John Pirro from Clark County and Government Affairs Liaison and Deputy Public Defender from Washoe County, Erica Roth. So with that, please approach. And please proceed when you're ready.
Good morning, Chair and members of the committee. My name is John Pirro. I'm a Chief Deputy Public Defender from the Clark County Public Defender's Office. I've been there. It'll be 11 years in May, so it'll be my 11-year anniversary. I want to talk to you about public defense in Las Vegas to start, and we'll go through a few things. You know our slogan, what happens in Vegas stays in Vegas. We've kind of gone away from that, but I do want to talk to you about some things and kind of show you what the differences are between us and what happens in Washoe County, and I think the next slide will paint a better picture.
Champion! 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 Hey, 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 hey.
Now what I see, sorry, skip that. What I just saw is a bunch of people having fun in our economic driver, our city. But what a deputy district attorney might have saw is a little bit of disorderly conduct running down the hall, a possible battery bumping into citizens, grand larceny for stealing that vase because casinos don't buy cheap objects, conspiracy to commit grand larceny from the whole group of people that were acting together in concert. And when you are on the hook for conspiracy, you're on the hook for everything else that happened, and possibly possession of stolen property at some point for that soccer trophy. Few things before we move on. These were the interns from last year from our virtual session. I do want to tell you that they did unionize and quit. They said the pay was too low, the treats were not good enough, and bill reading was too rough. That's your daily dad joke for the day. Now, in all seriousness, I do want to move on to kind of what drives our practice, and this quote is what drives our practice. Love is the motive, but justice is the instrument. We consider ourselves your community lawyer. 85% of the people accused of a crime cannot afford a lawyer. So we are your lawyers for your mothers, sisters, fathers, brothers, and cousins whenever they are accused of a crime. In 2019, before the passage of AB 236, Nevada was trending in the wrong direction when it came to criminal justice. We were incarcerating people at a higher rate than 15% of the states surrounding us, but we were also failing our women. We were incarcerating women at a much higher rate than almost all of the states around us. And AB 236 took corrective actions to kind of move in a different direction. We consider ourselves problem solvers and grace givers. All justice should be tempered with a little bit of mercy. Dr. Cornel West says justice and love is love in public, and that's what we do every day in our job. We are in the courts fighting for justice, fighting for people to be seen as a human being, and we move on from there. In the beginning, that's Clarence Earl Gideon. So he was accused of a crime in Florida. Gideon versus Wainwright is the United States Supreme Court case that gave us the right to do our jobs, get appointed counsel. Mr. Gideon was accused of a crime in Florida, went to trial by himself, was convicted, wrote on his own an appeal to the United States Supreme Court. And I know, Assemblyman Urick, you're a Boyd grad, yes? Right? When we originally entered Boyd, they used to give us a book, Gideon's Trumpet, which kind of talked about that case. He was appointed a lawyer at the Supreme Court, Abe Fortas, who eventually went on to become a United States Supreme Court justice. But before that time, Abe Fortas defended this case in the United States Supreme Court, which granted everybody the right to have a lawyer when they're accused of a crime. So it's a bedrock principle embedded in the Sixth Amendment of the United States Constitution that a person accused of a crime should be afforded a lawyer, or else you cannot assure a fair trial. And why is that the case? Because in our adversary system of justice, you need a lawyer to stand up for you. Abe Fortas went back to Florida with Mr. Gideon, defended the case. Mr. Gideon was acquitted. That's the difference that a lawyer can make. And Nevada was actually on the forefront of that, as Director Reba told you, from the Department of Engineering and Defense Services. We were one of the first states that really moved in with institutional defense. But I will say that that institutional defense is really only in Clark, Washoe, and there's a smaller office in Elko. The rest of the state suffers greatly under contract public defense. I want to talk to you about some celebrity public defenders. Senator Richard Bryan was the very first public defender in Clark County. I want to thank my northern legislators in the University of Nevada, Reno. When I first went up to UNR in 2017, there's a statue to Senator Bryan, and he's surrounded by all these benches of his accomplishments, but there was one bench missing, the very first Clark County public defender. There is that bench there now. I have sat in that bench and thought about how far we have come. I also do want to say that we also have room for other ones. I think Assemblywoman Hanson, you would make a very fine public defender. And, I mean, it is probably a route to Speaker. So I just want you guys to think about that. The numbers from our office. We have 115 lawyers. We are down from 121. Not for a bad reason, for actually a good reason. I do want to say that in addition to our elected officials that have come from the Public Defender's Office, since 2020, 10 public defenders have been elected to judge, and it has been numerous firsts in Clark County. The first black woman judge appointed to the family court bench came from our office. The first black judge ever in North Las Vegas came from our office. The first black judges ever elected outright. So Clark County had this history where we appointed judges and then they won retainment, but no black judge had ever won an election outright until 2020. And those lawyers from our office accomplished those firsts in the state of Nevada. So we are in the midst of hiring 8 lawyers right now to catch back up, but we are always, I would say, our caseloads are pretty huge. So we are always in need of more lawyers who are here for the cause. We are broken up into different teams, and there's a good reason why. Our office was first started, and we have our own Miranda case. So Miranda, the right to remain silent case from the United States Supreme Court, well, we have our own Miranda case, but it's got a bad history. We got sued for about $5 million by Jerry Spence when he came to town. Because we would have brand new lawyers handling murder cases and cases they weren't equipped to do, and an innocent man was accused, and we happened to fix it, but it cost the county quite a bit of money. So since that time, we have come a long way. We're broken up into different teams. We have a 6-week training program when you start with the office. But we also have a team that specializes solely in juvenile defense, a team that specializes solely in appellate law, a team that deals with Category A sexual offenses, a team that deals with Category A homicide offenses, and track attorneys, which is what I do, that represent everything from misdemeanors to, I would say, robbery with deadly weapon and kidnapping. We have a mental health team, which has been growing with time, and I do want to talk about some of the issues with that. So we took on the civil commitment process, and we handle about 3,500 of those civil commitments a year. As all of you know, we have a severe mental health crisis in the state of Nevada. Some of the case numbers are there on the side, but I do want to hammer on how big the mental health problem is, and I do want to talk about one issue here with a client. We've had an issue, and I think it's going to come before this body this session. There has been a severe wait while people were waiting to go to competency court, and then once they were found incompetent, meaning they couldn't understand the proceedings, we couldn't move on with the court case, so we're going to send a person to the mental health hospital to see if they could be restored to competency. But the wait has been so long that people have been waiting in jail at a cost of $200 a day to us, the taxpayers, while they're waiting to go to the hospital and be restored to competency. One of those waits resulted in the death of my client. He was in a cell with another mentally ill person, and that person murdered him while he was waiting to be treated. His case was not that serious, and there's a lot of regret that I have that we waited so long and we didn't push harder on the court to move this person out. He would still be alive. And he was not in there for a violent case. He was there waiting to get treatment so that we could get him back into mental health court and back on probation. And he was murdered while in the jail. We try to practice holistic defense, meaning that we have social workers, investigators, and mitigation specialists in our office. We are up from 7 social workers up to 9 now, and we've been running a pilot program with, we like to call them our probation concierge. So anybody that may have difficulty on probation, a client that you're like, well, maybe you were a borderline candidate for probation, but with a little bit of extra help, you will be able to be successful on probation. And so we assign a social worker to that person to help them with that, because they're the ones that really have access to a lot of the services and can make those community connections. And we have had great success running that program. So we're hoping that that remains a program that stays around for the long haul. What we do, we carry out the intent of our founders, like I said. Liberty cannot be taken without due process of law. Everybody, maybe Hamilton came back to the Smith Center. If you were lucky enough to see that play, it's a great play. If not, you could actually watch it on Disney Plus if you have some free time, which you probably don't this session, but maybe post-session. But Alexander Hamilton, defense attorney. Aaron Burr, defense attorney. John Adams, defense attorney. So we are carrying out the intent of our founders by doing what we do every day. We talked a little bit about holistic defense. I want to tell you that the system sees a crime, but we see a whole life. So what we've tried to move from, which when I first started, I think the system really looks at you and it says, why did you do what you did? But the appropriate question, if we're looking at a trauma-informed response, is what happened to you that brought you here today before us? There's 2 great books on that. Oprah wrote one. But also The Body Keeps the Score by Dr. Bessel van der Kolk. Those books have really informed our practice moving forward. And about a third of the women that come into the criminal justice system have extensive trauma that has happened in their life that has brought them to where they are. And I do want to tell you a story. I'm going to change her name, but I got permission to tell the story. When you've been in the system long enough, you start to see that sometimes victims become perpetrators later. And oftentimes, maybe we are the first person to run into a victim of sex trafficking because the crimes are not what you would normally associate with that. So, my client came from Memphis. She moved here. Two people were like, hey, there's good jobs out here. You should come out to Memphis and work. And when she got here with her son, and she knew nobody else but these people, they said, look, that's working at Amazon is slow money. You need to make fast money. And here's how you're going to make fast money. And they started pushing her into prostitution. Now, that may have been something that may have tipped off the police that something was going on. But the crime that did not tip off the police that was going on was that the gentleman that was sex trafficking her would break into cars at gyms, steal credit cards, and then he would make her go use them in the store so that she was the one that would be held accountable for this. And even though we brought this to the district attorney's attention, yeah, it got her away from the felonies, but we still had to plead her to 2 misdemeanors to get out of this situation. So it was frustrating that we did that. And in order to even get those 2 misdemeanors, we had to meet with detectives and explain what was going on. And anybody that's worked in the system knows that snitching can create large problems if anybody was to find out that you talked to police. So when we sent her back to the place where she lives, we worked with Seeds of Hope to put her in a safe house while she was in Las Vegas, away from everybody, until we got rid of the case, and then got her back to her hometown as fast as possible. But I worry about her every day. I worry about, will those people go back to where they all came from and search her out because she did talk? Those are concerns that we have, and those are some of the things that we deal with in our job. So we don't only just address the court case, we address the circumstances that brought the person before us. A lot of other things that we do, though, we also work on criminal justice reform. AB 236 put into place where there could be local criminal justice working groups. In Clark County, though, we have what's called the Criminal Justice Coordinating Committee, and we've been working together as a team for over 5 years now. And kudos really goes to the Clark County Detention Center that brought in the Department of Justice to kind of get us together as a working group where we have the sheriff, the district attorney, the public defender, a representative from NACJ, which is what I sit on that board as, representatives from the court, and that's how we work out solutions in the criminal justice system. So one of those solutions that we worked out was the initial arraignment court, where in Clark County, we see somebody when they're arrested between 12 and 24 hours to determine if they are appropriate to get out of custody, so that if a person is appropriate to get out of custody, they're released as soon as possible. If they're not, they're going to sit there. It has not been like that around the state. However, last session we did pass a major bail reform that lets people be seen within 48 hours because we believe that the word prompt means prompt, and that justice should be the same for every citizen of the state of Nevada, whether you live in Clark or Washoe or Elko or Ely. It should be the same around everywhere. The last thing I did want to talk about is, though, although we shoot for holistic offense both in Clark and Washoe, we're not quite the gold standard. I would consider the Clark County Public Defenders the gold standard in the state of Nevada, but the gold standard in the nation is the Bronx Defenders. They have eviction attorneys to help people with housing issues. They have family law attorneys to help people with family law, because it's not just one situation that a person is dealing with in a system. And if they have all these things that are coming from all sides, it's very hard to be successful. So if you could have somebody step alongside you, guide you through the process where you're going through that, you have a much better chance of success. And what RAND found, which is not some liberal think tank, what RAND found when it was studying the Legal Aid Society, which is a more traditional public defender society like our office, and the Bronx Defenders, was that over the long term, the outcomes are better. People are less likely to recidivate. People are less likely to spend more time in jail, saving taxpayers money. People have better outcomes. Families have better outcomes. So holistic defense is the model that we are shooting for, but we still got a long way to go. One of the things we do pride ourselves in is holistic representation, meaning that once I'm appointed to you as your lawyer, I'm going to ride this train with you to the final destination. And for me, that's always hoping that, I always tell clients, if I get you into a specialty court program, I want you to call me and I want you to tell me when your graduation is, because I will be at your graduation. I want to see that. And afterwards, I want to get coffee with you, and I want to talk to you about what you thought about the program was effective, what you thought wasn't effective, so I could take that back to the judges, and we can adjust and make things better. I've been asked to speak at 2 drug court graduations for our clients and other people's clients. It's one of probably the happiest times that we have. I'll also say that working with the Criminal Justice Coordinating Council, we've worked with the Department of Parole and Probation to make sure that we put honorable discharges from probation back on the calendar so that people are getting reductions. If they pled to a felony, but they successfully completed probation, they would get a reduction to a gross misdemeanor or a misdemeanor. So we're seeing more of those come through the system. We're seeing more and more success stories stemming from our work in the council, but also from AB 236. So I'm very heartened with the direction that Nevada is going in. I want to tell you what we don't do, though, and sometimes it's a misconception. What we don't do is get people out of jail for free. That's not what we do. If there's an action that you legitimately did, there's going to be consequences. But there's a lack of services. You all know this because you ran and you wanted to change things for the better. The sad part is, in the state of Nevada, it is easier for me to get you services once you have been accused of a crime than it is before you are accused of a crime. There are not many places that people can go to get help before they are accused of a crime. But once you are accused of a crime and we come up alongside you, we can get you services. And the sad part is, most poor people do not have insurance. So a lot of the times they go through their whole life with a mental illness that nobody has ever noticed. And we come into contact with them and we say, I think there's an issue here. We're going to send you to see some doctors. We're going to see what's going on. We're going to get you some treatment. Or there's an issue here. We're going to send you to get some drug treatment. We know that you've been battling this. And if somebody would have stepped in long before this crime was committed, perhaps the traumatization of everybody in the system would not have occurred. And so that's what we're always hoping for, is services on the front end, because right now we are fixing problems on the back end, and even the governor mentioned this in his speech. The jail is a difficult place to fix problems. And not only is it difficult, it's expensive. It's $200 a day for us to house people. And 1/3 of the population in the jail is on some form of psychotropic medication. So it's more expensive if they're not healthy in that way to house people. We spend $25,000 a year housing people in prison. These are costs to all of us that we could put in the front end and have dramatic cost savings. I went to a mental health summit just recently before coming up to the session. There was a judge from Miami-Dade County that talked about all the reforms that they did there. And one of the most prescient things that he said is that we were building more facilities. We were trying to build our way out of this problem. And we cannot incarcerate our way out of this problem. They took measures there in Miami-Dade. They reduced the homeless population from 8,000 to 1,000. They have a housing component to reentry where people are wildly successful. They have social workers there. They have people that are helping them get jobs there. So there's a component that we could take. It would take some front-end investment, but there are steps we could take so that we're not fixing things at the back end where it's more expensive and the traumatization of everybody in the system, including the victim, has already occurred. If we could stop that trauma on the front end, I think our state would be much better off. Some of the challenges facing our office. We do have high caseloads, I would say overwhelming caseloads. The lack of community resources, as I spoke about. There's this 80KT 411, which is a bunch of aspirational goals that the Supreme Court put out for public defense. I will tell you that it's ridiculously difficult to meet those aspirational mandates, especially with our caseloads. One of those, for example, is that every attorney should be with their client during a pre-sentence investigation interview. I will tell you, in near 11 years, I've never had time to make that happen, ever, not once. I have to give my client a pre-speech like, hey, let's talk about what you're going to tell them. Let's be honest with them about your drug problems and be honest with them about your childhood. One of the issues with trauma is if it's always been bad, you may not know it's bad. And so we have to sit down and talk with our clients about their childhood, because you'll see on a PSI report, and that's the only thing that the judge sees is the PSI, and it gives a brief history, criminal history, facts about the case, and then the judge has to make a decision about the person. And if you've only been in front of the judge the first time seeing for the PSI might not be the most accurate reflection of this person's life. For example, most people will say, "Oh, my childhood was good. I can't really remember anything bad happened." And then when you dig in, you're like, well, you were removed, and your mom was in prison, and your dad was in prison, and you were removed from the house. You lived with your grandparents, and you lived in foster care for a minute. And that's trauma that they don't even recognize as trauma. So for us not to be there, sometimes that's difficult, but I will tell you with the caseloads, I have not been able to be at one. The mentally ill population is growing, as I said, a third of the jail. The jail is basically our mental health warehouse, and it's so overburdened, and the mental health facilities are so overburdened that we don't even have room to move people in. So that's how my client was murdered while waiting, but also that a ton of mentally ill people are sitting there waiting to get treatment to see, one, if they could be restored to competency, and if not, continue on a mental health treatment plan. We are at a point where Miami-Dade was. We are trying to build our way out of this. We're trying to build a new forensic facility right now, but really we may need to just change what we're doing and change directions. Moving forward, resources for rehabilitation before a citizen enters the criminal justice system. Sealing records. This body has done amazing work since 2017 sealing records, and you may see another bill come before you here. Father Gregory Boyle, the founder of Homeboy Industries, which does amazing work with gang members in LA, says the best cure for crime is a good job. And so sealing records helps people get back on their feet, gets a fresh start. And so any more reform that we can move on in that direction, we'd like to move that way. Because once you've done your time, once you've paid your debt, you should have a chance to kind of start over again, hopefully. And teamwork makes the dream work. I think the Criminal Justice Coordinating Committee has done great work in Clark County. We'd like to see that model brought across the rest of the state, where we're all working together to find solutions to solve problems, not just up here during the legislative session, but down in the counties on a more granular level, where we're trying to find solutions for the problems that are plaguing our society. And that will be the end of my presentation.
Thank you for that presentation. Quick question, would you like to take questions now or wait until afterwards?
Madam Chair, if we could wait till after Washos, and then we definitely take questions together.
Certainly. Please proceed.
Good morning, Chair, the committee. My name is Erica Roth, E-R-I-C-A-R-O-T-H, and I'm here to present on behalf of the Washoe County Public Defender's Office. I'm going to echo many of the sentiments of my colleague, Mr. Pirro, this morning. I will note he did not tell me that he was going to show pictures of his dog. But as a public defender, I'm used to being on unfair footing, and so I'm still prepared this morning. So the mission statement of the Washoe County Public Defender's Office is to protect and defend the rights of indigent people in Washoe County by providing them access to justice through professional legal representation. Mr. Pirro touched on this a little bit with Gideon v. Wainwright and the right to counsel. And so I won't go into the details of that, but I will note some statistics that I think are important. In the United States, 80% of people accused of crimes are represented by public defenders, and 57% of incarcerated men and 72% of incarcerated women were in poverty prior to their arrest. And so these statistics are important when we're looking at who has entered the criminal legal system. They're primarily represented by public defenders because by and far they are not getting the services, they do not have the resources that they need to operate in this society. They need those services. Indigent defense impacts us all. Sometimes we can feel removed from this work, or people can feel removed from this work. And Mr. Pirro touched on this some, but this is the public defender's credo, and it's actually from a Florida district court case, and that's that indigent defenders stand alone, armed only with their wits, training, and dedication, inspired by their clients' hope, faith, and trust. They are the warriors and Valkyries of those desperately in need of a champion. Indigent defenders, by protecting the downtrodden and poor, shield against infringement of our protections, and in reality, protect us all. And this is important to me because when we uphold the constitutional rights of one person, we strengthen the constitutional rights of our entire community. It is the constitutional rights of each and every one of us that are protected when a public defender stands up and fights to advance or push back on any government overreach into people's lives. And these are the constitutional rights of our friends, our neighbors, our family members, and each and every one of us. So the Washoe County Public Defender's Office is broken down up here. We currently have 42 attorneys. Our office has expanded since the COVID-19 pandemic. And our teams are comprised of a Category A felony team, a felony team, misdemeanor team, juvenile team, family law and mental health hospital team, an appellate team, immigration team, and now government affairs. We have excellent support staff, an excellent mitigation specialist, now we have 2 on-staff social workers and social work interns. And I'll note that we did recently, now we have expanded the bench in Washoe County. In this last election, we had 2 public defenders elected to the bench, one of which is my predecessor, Ms. Birchie. And the second, Erica Flavin, Judge Flavin, is the first Black woman elected to the bench in Washoe County, and we're very, very proud of that. So our office also practices a holistic defense model, and I'm not going to repeat what my colleague said, but I will note when I spoke to one of our social workers, Natalie Choi, and I'm just going to tell you what she told me, and she said that why her job is so important is because we humanize our clients in a dehumanizing system. And this is done not only through a deeper understanding of our clients' life circumstances, but also by connecting them to essential services that are shown to reduce recidivism. And it's true, we see the full picture. Our clients come to us with a life story that other people are forgetting. And they are many times victims of crimes, of circumstances, of poverty. And it's our job to make sure that they are humanized because their lives matter. So this holistic defense model couldn't be done without our social workers. We now have 2 social workers on staff. Some of what they do is provide general support to our attorneys. They connect clients with mental health services, housing services, and other resources. They collect information for plea negotiations, background histories, so that we can present that information as mitigation and sentencing, and helping even with navigating the child welfare system. One thing that our social workers also do, and I think it's really important when understanding what it is like to be have been caught up in the criminal legal system, is our social workers often are asked by our clients to just visit with them. And I have had many clients who are sitting in custody who are deteriorating, and our social workers set visits with them simply to talk to them, to tell them that somebody cares about them, to tell them that they're not alone. They request our social workers to be with them at sentencing hearings, because our social workers build and have the time to build those really deep relationships with them. And that's not something that, as attorneys, we're always able to do. I don't have time to set visits with my clients just to tell them that somebody still cares about them. And that's something that they need. Some changes and challenges in our practice. I'll dig into some of these deeper than others as they've already been touched on. Our bail practice has changed dramatically. Diversion for drug offenses has changed dramatically in the last few years due to AB 236. We have seen a dramatic increase in wait times for treatment to competency, limits of statewide testing capabilities, and lack of data. And I first just want to touch briefly on the increase in treatment to competency. My colleague also discussed that. And I echo his sentiment that we can't build our way out of this issue. Last year, the Interim Finance Committee did approve American Rescue Plan dollars to build a new facility. And we need that. That facility is needed. The backlog, the wait times are unconstitutional. And that building is necessary. But it begs the question of when do we divert those resources upstream? When do we say we're going to fix the problem before they get to this point of being held in custody with severe mental health issues and now being had to be treated by the state? And so, I pose that to all of you because it is fiscally irresponsible to ignore how the state chooses to divert that money, where we're putting it in. And it's also a moral question of when do we treat people? So I'll touch briefly on our bail practice, which has changed significantly both since the Nevada Supreme Court's decision in Valdez-Jimenez and last session the case was codified in AB 424. So what resulted was that a bail hearing must be held within 48 hours of arrest. It is the state's burden at that evidentiary hearing to prove by clear and convincing evidence that every requested condition sought is the least restrictive means necessary to assure the accused's appearance at a future court date and protect the community's safety, and that the presumption at that hearing is of release. And so that burden was shifted to the state to have to prove that anything other than release is necessary, and that amount sent is still the least restrictive means necessary to ensure safety and return to court. Some tools that are utilized still, although we have moved away from a bail schedule, tools that are utilized in determining the least restrictive means is a promise to appear and obey all laws. These would be imposed on a client, that is. So we can require them to promise to appear, right? Make a promise. A warrant would otherwise be issued if they don't show up to court. No alcohol, no drugs, phone check-ins with pretrial services, random testings, mandatory GPS, Graham units, house arrests, and then lastly is cash bail. And so when an individual comes before the court for that initial appearance, they are met in Washoe County with our bail team. And since Valdez-Jimenez, our bail team has been built and is really a well-oiled machine. We have 2 full-time attorneys on that team, and all they do is handle these hearings. We have 1 investigator that is present at hearings every day, and these hearings are held 7 days a week. The investigator is essential because this is an evidentiary hearing. It is an opportunity to provide or to produce evidence, to cross-examine witnesses if necessary. But what's so important is that when someone is booked in the county jail, they're given an assessment, and the pretrial services will ask if they're employed. And if a client says, yes, I'm employed, but they're unable to verify that employment, that's a ding, right? If they say that they have a phone number or a place to go, but pretrial services is unable to verify that with a phone call, that's a ding against them. And so what our investigator is able to do is we see what they're scored initially, and our investigator is able to call their employment, to call their parents or their sister or their brother or their child and say, we have been able to verify that they do have a place to live, that they do have a place to go, that we are able at this point to connect them to services. They're also able to, at this point, we can start working with our social workers, see if we can get them into treatment if that is necessary. So all of this happens within the first 48 hours of arrest, and it's essential. It has changed our community for the better. We are able to ensure that families stay together, that our clients don't unnecessarily lose their housing, their employment, custody of their children. All of these things are essential in the first 48 hours. And so I'm very, very proud of the work that our bail team does, and I see every day how much it has really impacted our community. And I'll just note on that, one thing about bail is that, and the changes in the law, is that it requires that an individual is seen within 48 hours, even if there's a holiday, even if it's a weekend, right? And I asked a member of our bail team to pull just some data on individuals who were released. They were given a bail hearing the day before Christmas, and they were able to spend that holiday with their families. And these are, the argument swayed the court, and it matters. These things matter. The day matters when you're able to say, I have a family, I have a job, I need to be with my child, I have a baby. All of these things, it really matters. Touch briefly, we have a range of felony diversion and specialty courts in Washoe County. And this is really important with the changes in AB 236, which requires diversion on certain drug offenses. And so these diversion courts are essential to ensure that our clients are able to succeed on probation, diversion. But what we hear time and time again, and we have excellent, the Second Judicial District Court has done an excellent job with these specialty courts, but our clients need more services. And that is something that we hear time and time again. The greatest challenges that we hear facing our clients in succeeding, number one, across the board, affordable housing. Absolutely. Our clients are largely unhoused. They often lose their housing vouchers as a result of being arrested, and it is the absolute number one issue facing our clients that is reported to us. Other challenges are the lack of substance abuse treatment beds. This again goes back to moving upstream. How do we address this beforehand, and same with mental health services. And then another thing that I think is really important is lack of affordable childcare is something that we really hear from our clients frequently. Another issue that I raised, one of our challenges, is the limits in statewide testing abilities. And this is in relation to testing drugs in a range of cases. And so our current statutory scheme for possession, sales, and trafficking of drugs is a weight-based scheme. So we determine that a certain weight of a substance qualifies for a different level of crime. However, our testing capabilities in the state are limited. And so a qualitative test shows only the presence of a particular substance in a specimen. And that is the testing scheme in the state of Nevada. There's no testing ability in the state of Nevada that provides for a qualitative test, which shows how much quantity of an analyte is present in a specimen. And this is incredibly important right now as the landscape of drug use and manufacturing changes in the state of Nevada. As many of you are aware, fentanyl is now found in most drugs. And so what that means, though, is that when the testing capability is limited to just simply determining that, let's say fentanyl, for example, is present in the drug. We are not capable of determining what percentage is present. And so I'll give you an example. Public defenders love visuals. But this here is 1 gram. This is a gram. And if there is a substance found on an individual, let's say there's 4 grams found on an individual, the state's testing capacity at this time does not have the ability to determine whether this much is methamphetamine and this much is fentanyl, or this much is fentanyl and this much is methamphetamine, or the most likely scenario that this much is methamphetamine and a teeny tiny itsy bits of this is fentanyl. And so it poses challenges as individuals are charged with certain offenses, and how we're able to determine what they can or cannot be charged with. And so I want to set that landscape now. It's very important to understand that these testing capabilities are not adequate in the state. Any changes of law would be seriously impacted by that lack of capability to determine what percentage of a drug is what drug, given that everything is now mixed. And then lastly, I want to move to just a few case highlights. And I think it's important to demonstrate a few different cases that are very common in our practice. One of them, so first I highlight this first case, number one, because of the weight of the drugs that were found on our client. And then second, the services that were provided to him that allowed him to succeed. So our client was found with 22 gross grams in weight of methamphetamine, so that would be 22 of these, and was originally charged with trafficking of a controlled substance. Often clients are charged with trafficking of a controlled substance based solely on weight, even if they're not found with a scale or baggies or any other indicia of actual sales. After negotiations, the individual pled guilty to a Category C felony. And when he was in custody, though, pending sentencing, he was transferred. He was granted an own recognizance release to the Delancey Street Project in San Francisco. And this is a really amazing program. They teach individuals to be teachers, is what they say. But it is a holistic practice. They provide housing, services, help with employment, and long-term employment, CDL licenses, things of that sort that sets them up for life. And I just highlight this case because he was granted probation. He is now 6 months out. He is doing incredibly well. And we can see this. When somebody is found with a large amount of drugs on them, it's not the end of their story, right? They are a human being. They are capable of succeeding, and they deserve that chance to show the community that they can succeed. What they need is those services to do it. And then lastly, I want to talk about Miss Rohr's case. And this case is important, and I might get a little choked up, I apologize. This case is very important because Miss Rohr, her life story is the story of so many of our clients. And Miss Rohr grew up in rural Virginia in abject poverty. She had no running water, no electricity. She was abandoned at the hospital as a child. She was eventually raised by her grandparents, but left their house at the age of 17, and over her life was the victim of repeated domestic violence relationships. Those relationships resulted in the removal of her children from her home because of the circumstances of that domestic abuse. And she did eventually find herself living homeless in Reno, in an encampment along the railroad tracks. Now, Miss Rohr's was charged with open murder when the victim was found along the railroad tracks, and that was near where Miss Rohr was living. There was no DNA or forensic evidence linking Ms. Rohr to this crime. And when Ms. Rohr was initially interrogated by police, she was interrogated for 9 hours. And during that time, she maintained her innocence the entire time. She was brought back for another interrogation of 5 hours, where statements were elicited from her, and ultimately, she was convicted at trial. Now, this case was just overturned by the Nevada Supreme Court. And the court ruled that the district court erred in granting a jury instruction which effectively instructed the jury to adopt the state's argument that Ms. Rohr's confession was voluntary, and that the court erred in restricting Dr. Leo, who was the false confession expert in this case, and an alumna of my law school, I'll give him a shout out, from identifying and commenting on the interrogation techniques used by police in this case. And so this case was an injustice, and Ms. Rohr deserved to have a fair trial. She was, but I bring this to all of you because her story, like I said, is the story of so many of our clients. Her interaction with law enforcement, her life circumstances, all of these things contributed to this conviction. And I want to give a shout out to the attorneys on this case, Evie Grosnick and Catherine Reynolds. Ms. Reynolds also argued the appeal. We see these facts, these circumstances every single day. And I want to take this time to remind everyone here that our clients are humans. They have trauma that they have experienced their entire lives. And they deserve to have justice sought on their behalf. And with that, I think we'll take questions.
Thank you, Mr. Pirro. Thank you, Ms. Roth, for your presentations. With that, our first question will come from Assemblywoman Bilbray Axelrod.
Thank you, Chair, and thank you for being here today, both of you. I think we're all kind of tearing up at different points. Mr. Pirro, my question is for you. You mentioned a task force that was put together by the detention center. Could you expand on that a little bit and tell me if you're still meeting?
Yes, Assemblywoman John Pirro for the record. We are still meeting. The Criminal Justice Coordinating Council meets every 2 months, sometimes every 3. We have subcommittees that meet regularly as well. One of those subcommittees was the one that designed the initial arraignment task force. Another one was fixing some issues with parole and probation, working as a team together. So we still are meeting regularly. Right now, somebody's taking my place. We're working on deflection and diversion. So one of the task force that I'm assigned to with Judge Harris from North Las Vegas is deflection and diversion. Deflection being, how do we prevent something from happening, from the case even coming into the system in the first place? Diversion being, once you're accused of a crime, how do we minimize the consequences and impact and your exposure to the system so that you can have the best result possible in that way. So we're meeting there. What I've learned from this is there's a lot of programs right now in Clark County, but everybody's working in a silo. And everybody says, well, oh, our program does X, Y, and Z, and then our program does X, Y, and Z. So there's, one, a lot of duplication of services, and 2, a lot of people are falling through the cracks. So what we're trying to do on that subcommittee is kind of find out, where are we duplicating? How can we get a one resource allocation? And sometimes the solution isn't always a good one. Right now, we have what's called the strip corridor court. So if a crime is committed on the strip corridor, it's going before a particular judge in a particular courtroom. And right now, this is our temporary solution to kind of tamp down things on the strip because obviously we don't want problems on the strip. But there's not a ton of services that are going into that court, right? So our measures are basically punitive. What we need to figure out is how can we do this in a way where we're, 1, reducing crime on the strip, but 2, making sure that when the homeless people that get out and have nowhere to go, they're not going directly back to there. So we are still actively working on solutions. I'd like to see this taken more statewide, and AB 236 provided the framework for that. And again, I give the shout out to the Clark County Detention Center. They're the one that did the grants and got the Department of Justice to come here to work with us on that, because the jail population was too high. People were sleeping on cots at one point in the jail. And we've worked on reducing the jail population. At one point, so we have the Clark County Detention Center downtown, but we also have the North Valley Complex. At one point in the county's history, that North Valley Complex runs solely on overtime. Not enough people to staff it because we were having such problems. So we've moved away from that, but we still got a long way to go, and we are working together to find solutions.
Thank you, Mr. Pirro. Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you so much for coming and presenting on these important issues today. So my question is on the 48-hour requirement for bail. We have heard in some presentations over the last week that that is a huge burden on the rurals. And I understand you are not representing those districts, but I would love some insight. We were told one of the big issues is getting attorneys there in these rural areas, especially public defenders, and that was a challenge. And that maybe the rurals would need some kind of exception. And so I just wondered if you could speak to what you've seen on that issue.
I'll speak to that. And I cannot, I'm sorry, Erica Roth for the record. I can't speak specifically to the experience of the rural counties or attorneys. What I can say is that there is a requirement that the state provide indigent services across the board. Someone living in a rural county is entitled to the same constitutional protections as someone living in Washoe or Clark County. And it's also important to note that we have learned a lot through the pandemic. There is video court capabilities. There are other solutions to ensuring that an individual who's brought before a judge in White Pine County or another rural county is getting those same constitutional protections, and that is a mandate of the state.
If I may as well, John Pirro for the record. Yes, I have heard those issues. We are in discussions, and I definitely think that that's going to come before this body, right? In law was the word prompt, though, and prompt to me means prompt, right? If we're looking at Merriam-Webster's dictionary, and I echo the sentiments of Ms. Roth that, like, I am concerned that people are getting less justice maybe somewhere else than they would be in Clark County. And I will say that with that legislation, AB 424, we worked in the ability to do Zoom courts. We also worked in like a legislative fix to let judges from other counties cover for each other. So like we tried our best to kind of cover all the bases to try to help folks out, as well as delayed implementation. I think we gave a year runway for implementation. It wasn't a right-away fix.
Thank you for that question. Next question comes from Assemblywoman Hanson.
Thank you, Madam Chair, and it's good to see both of you here today. I appreciate the shout out, but I think my 8 children who at one time were teenagers would differ. I was quite the prosecutor at the time, and it worked to my favor. They're really wonderful, decent human beings who so far haven't had too much trouble with the law. But anyway, that being said, and just to qualify, I love this process. When we talk about our system, and I say it again and again, a daughter of a district attorney and leanings toward public defenders, because that's the system. I love the tension. That's how it's supposed to be. This is really what debate looks like, if you've ever done that in high school. And so those who might be new, we might feel like, oh, I have feelings toward this side or have feelings. That's how it's supposed to be, because when it really comes down to it, the burden of proof is on the prosecution for that weight, and you have that due process that you've got to protect, and hopefully somewhere in between we get where we need to be. So thank you for all that both sides do, and I tend to side with one or the other, usually. So as we talk about the commitment, those really bother me, those numbers, the civil commitments. And we all agree that there's a mental health crisis in the state, probably in the nation. going back to the day when I grew up, I want to see how you feel from the public defender point of view, even though this is probably a mental health and human services issue. Back in my day, those with really difficult mental health challenges, we housed them in mental health facilities, sometimes not with the best reputations. We all know of One Flew Over the Cuckoo's Nest. So I'm wondering, has the pendulum swung too far the other way? That we released a lot because it was broken. The system was broken in finding a way to institutionalize, for lack of a better word, those with probably pretty severe mental health issues. Are we now paying a price for that? And do we visit maybe having those kind of facilities again in the picture, done right? So I would love to hear your take on that and how that would affect what you're having to deal with on the streets and these people in dire situations.
John Piro for the record. I think one of the major building blocks is housing, right? So housing is something that we have to figure out. We're in an affordable housing crisis. And I agree with you that when the institutions were abolished, we had no good solution to solve the problem. And so we just dumped people into the street, carte blanche. One of the things that we know with mental illness is lack of sleep can exacerbate mental illness, right? And when you're homeless, there is not a safe place to sleep. In Las Vegas, we had people murdering homeless people on the street. But you also cannot get comfortable at night to sleep, nor is there any real place you can go to sleep. We as a society, we are okay with having a whole community of people living in the tunnels of Las Vegas, that we have not tackled that problem. There's a whole ecosystem of people there that we have left behind, right? And some of those people are struggling from mental illness. Some of those people are struggling from drug addiction. And some of those people, what we've learned in practice is that a lot of times, if you have a mental illness and maybe it hasn't been diagnosed, or maybe it even has, you are using drugs to cope with the effects of that mental illness. One of my clients said probably the most impactful thing that I've heard in my practice. He's like, listen, these voices in my head, they're very mean to me. They attack me frequently. I use methamphetamine because that's the only time I feel good. That's a time where I feel euphoria, and that's the only time that those voices are kind to me. And so he's currently in mental health court getting treatment, but you are 100% right that we have no solid solution. And at a certain point in time, I don't know that an institution is the right way, but I do know that having community services that are accessible and that are reaching out to folks where they are is probably the best solution. Because right now, you could get dumped out of the Clark County Detention Center with maybe a day's worth of medication, and they will tell you, hey, I know you've been stable, but we're kicking you out. It's 2 a.m. and find your way to Southern Nevada Adult Mental Health and start getting those services, right? So we don't have pathways and a runway. We never had a runway once we ended what we did, and it's time to find that.
Erica Roth for the record. And I just want to add briefly that our jails and prisons have become those mental health facilities. That is what those are. And so we are paying for it one way or another, and it makes sense to divert those resources upstream. And I can't opine on I'm not an expert on the best way to treat mental health, right? But we do have those experts, and I think that to utilize that information to say that this is what works, this is what doesn't work, but these resources are being spent already because we're jailing everybody. And so, I think that you hit the nail on the head. That's exactly what we're arguing. But, from a fiscal standpoint, the cost is already being borne.
Thank you for that, and thank you for your question. We have 3 more questions from members, and then we're going to move on because we still have 2 bills coming that I have a feeling are going to warrant a number of questions. The next question is from Assemblywoman Newby.
Thank you, Madam Chairwoman. Can you talk to, and thank you for your presentations, both of you. Can you talk to me about conflict counsel? What proportion of the clients coming to the PD are handled by conflict counsel? And do those folks access the same sort of wraparound services like the social worker as well if they're being handled by an outside counsel?
Erica Roth for the record. I don't have those exact numbers for Washoe County. That is something that we can pull, absolutely. The process for conflict counsel in Washoe County is we have both the alternate public defender's office and then also a conflict counsel panel. And so if an individual comes to our office and a conflict is determined, maybe we represent a co-defendant or a victim in the case, their case would be transferred first to the alternate public defender's office, and then if they have a conflict, there is a panel of attorneys who would then take it. That process can be long, and so we do often see individuals sitting in jail waiting to speak to an attorney because they have to keep getting passed down the line. So the exact numbers I don't have, but I think that is something I can pull if it's of interest.
Jump here for the record, same thing. I do not have those numbers, but I can tell you two things. We do have the special public defender that deals with category A felonies, so the most serious ones, and they do have social workers and mitigation specialists. But those cases are generally more serious where you're looking at prison time as the result as opposed to probation. Then the other thing is what we would call track conflict counsel. They do not have the resources that we have. They have a static paycheck. Doesn't matter if they take one case a month or 100 cases a month, the paycheck is the same. So they do not have access to a social worker. They do have access to an investigator, but they do not have the resources that our office has.
Thank you for your question. Assemblywoman Hardy?
Thank you, Chair, and it's good to see you, Mr. Pirro. I've known you for several years, and I know that you do amazing work in Clark County, and Ms. Roth, I look forward to working with you. So my question is, it was mentioned several times, and I know we talk about this a lot, about lack of funding and how, money can help solve a lot of our problems and deficiencies. But if you could just maybe share with us some solutions that you've found that you use currently, and maybe some things that you have in the works, just depending on the funding you are asking for doesn't come, or, we see there's always a lag in the money. So if you would share some of those things you're currently doing or some ideas that you may have, in the pipeline as far as staffing or other services. Thank you.
Jump here for the record. Thank you so much for that compliment, Assemblywoman. For us, unfortunately, a lot of it is based on the treatment courts for court. So we have drug court, where if a person has a drug issue, that's where they're getting treated. We have co-occurring court, where, and I've ran into the situation, so I want to give a shout out to Judge Yeager, Speaker Yeager's wife. She was the one that created co-occurring court. I had a client in particular one time where they were like, it's not really, the drug problem isn't the big thing, it's mental health stuff. And then when I send them to mental health court, they're like, well, it's not a serious enough mental health issue, the drugs are more the issue. So then he goes on probation with no court and predictably violates on probation. And kudos to Judge Yeager for putting that court together where we're kind of dealing with the intersection. And then you have mental health court, which that really is our best thing that we have going. That's the one that has the housing piece. That's the one that has the treatment piece. That's the one where they're monitoring treatment and medications and figuring out what's right. Because again, I am not a doctor, but I think all of you know that with formularies, like even if you move from, let's say you're being treated for bipolar and insurance changes your formulary to maybe a generic drug, it has ripple effects in that person's treatment, right? And there's an adjustment period, and there are problems that happen there. And so mental health court is really great working on that. And we have done some great work with the legislature in extending Medicaid, getting people on Medicaid sooner so that when they get out, they have kind of an ability to obtain medication. But the one thing that everybody is talking about is housing. If you can get somebody housed for a while and give them a safe base to get clean, to get medicated, to get treated, the success outcomes are wildly better. So that's one of the main things that we would like to see worked on. And those are kind of some of the things that we're talking about in the Criminal Justice Coordinating Council, is talking about like, what can Clark County do to bridge that gap in housing? And not just like, hey, look, we got a place for you for 90 days, and then after 90 days you figure out what you're doing, but more kind of like, let's help you get on your feet. Let's help you get those wraparound services that you need. Let's make sure that transportation is a thing that actually works out for you. You know how to use the bus system, and you get to your appointments and get your treatment. So wraparound services probably would be my ask.
And I'll echo that and make one more point. First, I echo the need for housing, and I'll just note, I've heard an argument that some people just don't want treatment. They're not ready for treatment. But if you are not housed, if you do not have shelter and food, and are clothed and have those basic human dignitary rights, the last thing on your mind is doing the 12 steps, is doing a personal inventory and, making amends. You have to have those basic resources before you can do the work of treatment, which, so I'll start with that. And then second, as far as funding, again, echo my colleague here. And I'll also say data. It's important on a macro level that we're operating from and making decisions from a place with data that is evidence-based and not reactionary. And I think that the state in the last few years has done some really great work with the Sentencing Commission, and the state of Nevada, although we are far behind, we are working towards being able to make decisions from a place of data. And so I think there's the micro level, and on the macro level, I would say that.
Thank you for that. And our final question is from Assemblywoman Considine.
Thank you, Madam Chair. It's kind of a two-part question. The first is there sort of a standard or an ideal amount of PDs per clients? Is there like a number across the country where this is where this has been figured out, how many you should have? And or if you could each potentially answer or send that information for each county, how many additional public defenders would be needed to provide the constitutional legal representation at every step of the way, and I'm including like the PSIs. How many would be needed for each county?
So I think that's a great question and gets to this need for data. I don't want to speak on behalf of any other departments. If my memory serves me, there is a study being done as far as caseloads, and this, I may be incorrect about that. I'm looking over my shoulder at Ms. Gonzalez with the Sentencing Commission. But there are larger studies done. The Vera Institute often does these kind of studies, and so I think that there is, on a nationwide basis, that data probably exists. Exact numbers I could not give you right now. And I'm sorry, Erica Roth for the record.
John Pirro for the record. We did do a study. I can get you the data from that study. And that study's old now, though. That's when our office got sued when we were woefully inadequate. But I can get you the caseload study that the National Association wound up conducting on our office, if you'd like. That being said, I will say that our caseloads are overflowing, much like district attorneys' caseloads are overflowing as well. For us, if I'm looking at a standard year, I could be handling anywhere from 300 to 400 cases. And that's felony, misdemeanor, mixed in, period. And so that's a tremendous amount of people to talk to throughout the year. Well, I would say in a given week, I'm getting anywhere from 5 to 12 cases a week.
Thank you for your question. Thank you, Mr. Pirro and Ms. Roth. With that, we will go ahead and close the presentation. I will give, our next agenda item is Assembly Bill 32. So I will open a hearing on Assembly Bill 32. It will be presented by Victoria Gonzalez, the Executive Director of the Nevada Department of Sentencing Policy. And when you were referenced, I was looking, I was like, well, I don't see her. So I'm glad to see you hiding over there. So Ms. Gonzalez, when you are ready, please proceed.
Good morning. Thank you, Chair. Good morning, members of the committee. Again, my name is Victoria Gonzalez. I'm the Executive Director of the Nevada Department of Sentencing Policy, here to present all the information you need to understand everything about AB 32. So one of the things that I meet with stakeholders a lot, and some of them have commented, well, you say that a lot, and I just want to say it again. We're nonpartisan. I do not have a political agenda. I'm a state agency, and we were built to help this state, the lawmakers, the stakeholders, the public, make truly data-driven recommendations. That does include qualitative and quantitative data. And based on the data that we collect and analyze, the recommendations that you will hear me present will be a combination of our findings as a staff, what we have found in the state, or in the data we've been collecting and analyzing, and a combination of discussions and recommendations that came out of the Sentencing Commission. So what you see in AB 32 is a combination of a recommendation came out of the Sentencing Commission mostly by a majority, but that of course means there were differing views. So we provided additional materials to help you see all those views and to help emphasize what we are here to help you really do when it comes to making these policy decisions, making sure you have all the information in one place and not just one perspective on the data and the policy, because there's many pieces to understanding that. So I'm going to start out with what the purpose and the goals are of AB 32, and then lay out the framework of my presentation today, which will include, of course, walking through the bill. So I'm going to start by identifying those goals. Next, I will provide background information for sections 4 and 7 and 5 and 8, as this is the most complicated portion of the bill and has taken the most work to develop and continues to be a work in progress with stakeholders. Then I will share data that supports those sections of the bill and how we came to this recommendation. After the data, I will present a walkthrough of I will walk through the bill, and then I will conclude with a summary of the amendments that we have already been in the process of developing with stakeholders. So as I want to emphasize again, we are here to help you make data-driven recommendations. The intent and goal here with AB 32 is to improve implementation of policies that were enacted in AB 236, just a couple of those, based on the data that we've been collecting and analyzing. And then some of the other sections are working to improve the stability, the sustainability and the stability of our new agency, as were established to be data-driven. And so the changes that we have in here are to make sure that that continues to be the case and that we can continue to exist for that purpose. And as I noted, we've been working on amendments. I want to start with a couple of the basics. I took inspiration from the policy brief that was presented by staff and put up here just an outline of probation and parole, the distinction between that. So for your information, for those that are not familiar, probation is generally covered in 176A of NRS. So when you navigate those sections of the bill, you'll know 176A means we're talking probation. If you're in 213, that means we're talking parole. So a reminder, probation is someone's been convicted of an offense, but the sentence has been suspended, and they've been given the opportunity to be on probation, and there are conditions that they must follow while they're being supervised. And then when someone's on probation, it's the judge over the case that makes decisions about violations. When you're on parole, someone's been convicted of an offense and served at least their minimum sentence in a DOC facility. They've been released to parole at the discretion of the parole board to serve the remainder of the sentence. And just so you know, a term you're going to hear is tail. So when someone gets released to parole and they're serving the remainder of their sentence, we'll refer to that as their tail that they're serving in the community. While you're on parole, there are conditions, again, of supervision that you must follow. And then in the case of parole, the parole board is the entity that makes all the decisions about violations. So in general, very high level understanding of violations and consequences when you're on parole, and this does, or on supervision, and this does apply to both probation and parole. So what does it mean very generally to violate supervision? It means you could have technical violations. Means you could have committed a new offense while you were on supervision. You can also violate supervision by absconding. The consequences vary based on this. So technical violations came out of AB 236, which I'm going to explain, because we did not have those in statute before. They were in practice and policy with the Division of Parole and Probation, but they were not in statute. But what we have now in place for technical violations are a matrix of graduated sanctions that the division must exhaust when responding to technical violations. And then the next level after exhausting graduated sanctions is temporary revocations are imposed. And again, I'm going to explain those. If you commit a new offense, you could face either the penalty for the new charges for the offense and or revocation of your parole for the term that you were serving in the community. And then if you abscond, you're facing a potential revocation. And again, for those, the finding of those is ultimately made by the decision maker, whether you're on probation or parole. So it'd be the judge or the parole board. So here's what AB 236 did. It was expansive, as we all know, the criminal omnibus bill from 2019. There were many policies that were identified in AB 236 that the reforms were attempting to advance. The specific policy that we're going to keep in mind today is the policy to implement swift, certain, and proportional sanctions in response to supervision. And that was the bar that we used to measure, are these working? And so the data we collected was measure against this policy. Are these policies and reforms are swift, certain, and proportional to what's happening while you're on supervision? So what AB 236 was, it did is it statutorily defined technical violation. So remember, for probation, that's going to be in 176A, and that's in 510, and this is for probationers. For parolees, it's in 213-15101. The definition's a little tricky to read because it's a negative. It exempts everything that's not new offenses. And it makes it very clear that those new offenses are not technical violations, which means, by definition, anything else is a technical. What was also established in AB 236 was the creation of, or the codifying of the use of a graduated sanctions in this matrix, which P&P has developed. And so that's laid out in the appropriate section based on parole and probation. So what happens, I'm going to go through the process more in depth as well, but generally what AB 236 was in response to technical violations was a series of what they refer to as temporary revocations. And so for the first temporary revocation, in response to a technical violation, it's 30 days. The second is 90 days, and the third is 180, and by the fourth or subsequent, you're facing a full revocation. So here's how it works on a high level, and this would be for both probation and parole. What would happen is while someone's on supervision, P&P is going to use their matrix to respond to the technical violations. As different technical violations come up, P&P will respond to those using the matrix to apply the appropriate sanction. Once they've worked through those sanctions, and they're guided by the risk level of the individual and the severity level of the violation. And that based on where they are severity, or risk level, and then where they are severity will determine what sanctions are being imposed. Once those have been exhausted for technical violations, again, it's not happening for one technical violation. It's happening based on what is appropriate to the matrix. Then if we've exhausted the sanctions, P&P will seek a temporary revocation for that for that 30 days. So what they do is, what would happen is the probationer or the parolee would serve up to 30 days for a first. Then they would be released back into the community, and then P&P again repeats the process of using the matrix of the graduated sanctions to respond to the technical violations. And then if we get to the point again where they get exhausted, you go for a second and you get to that 90 days. So as you can see, you work your way through each time the individual is released back to the community, and then P&P again applies the graduated sanctions. So what happens for parolees is very, very different than what happens for probationers. That's what this illustrates here. I have a very small note under here because the probation procedure is just more streamlined. Probationers do not go through this process. I just want to emphasize that. Happens to probationers is they're brought before the court after there's been an alleged violation within no later than 15 days after they've been arrested for the violation to address the temporary revocation, and the judge makes their decision. But what happens to a parolee is first, we've worked through the graduated sanctions. And so now there's an alleged violation. So what happens is PNP will arrest the parolee and they are held in custody in a jail. While they're being held in jail, PNP will hold a probable cause inquiry within 15 days of the arrest to determine if a violation has occurred. If they find probable cause, then what they will do is submit a violation report and a retake warrant to the parole board. The parole board then reviews that to determine should they hold a hearing to make a decision about whether or not there has been a violation. A parolee is a felon and must be held in custody in a facility of the Department of Corrections. So what happens is the parole board, if they think there's probable cause that a violation has occurred and a hearing must be held, they sign the retake warrant. The retake warrant goes back to the jail and requires the parolee be moved to DOC to await their hearing. So again, the probable cause hearing happens within 15 days. You've got the time for the parole board to sign the warrant, and then there's a time that happens while the parolee is still sitting in jail waiting to be transferred to DOC. Once they've been transferred to DOC, the parole board has up to 60 days to hold the violation hearing. And the parolee is sitting there waiting. And I'm going to show you the data of what we found about the length of stay for each of these phases. So again, that hearing happens within 60 days. Based on whatever the parole board finds, if they find that enough technical violations have occurred, then they will order a temporary revocation. And then depending on if it's your first for 30, second 90, and so on, will determine on how much time you're required to serve in the DOC facility. And then once you've served that time as a parolee for a temporary revocation, then you need to be processed for release. DOC is built to house long-term stays. They're not built like jails. So it does take some time for them to process these parolees back out into the community in a way that does take longer than if they were in a jail. And then once you've made it through that process, if you get back out to supervision and you still have your job and your house and your support system, then you would be subject to supervision again for the technical violations. And then if you were to face an alleged 90, then you'd be working through this process again. So obviously there were some concerns about this as it was being implemented. Several months after AB 236 went into effect, several criminal justice agencies, I was having conversations with several criminal justice agencies and brought this concern to my attention because they were looking at it from the caseload level and what it was doing to having to process these individuals. And so what we did pretty soon after these conversations started was I needed to learn more about this process. So they taught me more about how this actually works, and we started to figure out what data do we need to collect to analyze this policy. Our initial data collection started and included data from July 2020 to February 2022. This first data collection was very, very limited. We only asked for a few data elements. We were still getting our feet under us. I didn't have all the two analysts that I have now. And I had a very strong analyst who understood the system, but we were trying to do this preliminary test of what's happening. I also made a request for a report to get some information about what do we know about those lengths of stays in the jail. The jail data we're still trying to get, but I was able to get some preliminary information, and I'm working on getting some more updated information about that. But here were our very initial findings that led to this recommendation. What we found was that based on data I had from CCDC and at very high level, anybody who was being held there for the purposes of the Division of Parole and Probation or for supervision was sitting there anywhere between 10 to 30 days. And so I couldn't disaggregate who were the parolees, but we used that data to compare to what was happening before they went to DOC. Our strongest data was with the DOC data.
Ms. Gonzalez, we are really appreciating the background information on this, but I already anticipate that members are going to have plenty of questions. So I was just wondering if we could get to the actual sections of the bill. Thank you. Let me turn the mic back on. Yeah, just tie the presentation portion back up so we can get to the actual components of the bill.
Yeah, and I have an outline table I have in the slide just to help you navigate the bill.
Well, and
Oh, yeah, go ahead.
and we don't have that on Nellis, so we're not able to kind of go through it. But yes, please proceed.
So for Dory Gonzalez for the record, so should I just try and speed through these slides, I guess just to make sure, or jump to the bill?
I think we could probably go to the bill.
Okay.
And then I will ask you at the end, which is actually me asking you now, if you could submit that for the record so that we would have it back to refer to.
I did. I submitted it late, and I apologize for that. I submitted it last night, and so I've got multiple materials to help support this, and so yes, I did submit that in advance, so I apologize for the delay.
Thank you.
Victoria Gonzalez for the record. So, so Section 1 of the bill is specific to those recommendations that I was mentioning regarding making sure that our agency is going to be sustainable for collecting data. And so that first section revises the duties of my position. When it was created, my position, the director position, was the only requirements were them to be an attorney. And that, in practice, while worked out for everybody today, I'm worried about the sustainability of that in the future, having the appropriate leader to have the administrative experience and the data collection analysis experience in order to lead. And so by removing that requirement that the director be an attorney, it will be left up to the commission to put out the qualifications that they think would be appropriate when it's time to hire a new director. And so if they want to require that their future director, be an attorney, they have that power, but they're not going to be held by statute. And so it allows for the flexibility of what are the needs of the department and for leadership. Section 2 revises the membership of the commission. So you can see in paragraph M, what was set up before was we did have somebody appointed from the Division of Parole and Probation. And so what this allows for is to allow flexibility for who appoints that person. By statute, the Department of Corrections Director and other positions are just statutorily members of the commission, so it made sense to have a criminal justice agency have a similar appointing authority mechanism to those criminal justice agencies. Similar to the director of the Department of Employment Training and Rehabilitation, just giving them flexibility to appoint who they think is the best expert to be on the commission. The directors that we've had so far have been capable of that, but they asked for the authority to have the flexibility to appoint who they thought was the best suited to give the information to the commission that they need. Section 3 came at request from the Division of Parole and Probation. So this section is specific to sex offenders, and there's a corresponding section for this is for the probation section. So there's a corresponding section to the parolees. And when someone is put on supervision, there's a risk assessment that's conducted to determine the risk level of the individual, which helps the division customize and determine how to supervise this individual. And so what this does is just change just for sex offenders, change it so that it's the appropriate risk assessment tool. The Nevada risk assessment tool is not always appropriate to sex offenders. They need a more tailored, specified tool, and so the division just wants to make sure they have that flexibility to use the tool that's the most appropriate. I will note that in discussions of the Sentencing Commission, the question that was brought up was maybe we could put something in there that does say it needs to be evidence-based or supported by research as determined by the division. That recommendation was not voted on, but I wanted to share that with this committee. So sections 4 and 7 are the changes that we are recommending, and this was voted on by a majority of the commission, that we are recommending to address the issue that I was explaining in regards to responding to those technical violations. Because what we found, our data found specifically that parolees were spending somewhere between 60 to 90 days if you add up that jail time in a rudimentary way with the time they're spending in DOC for a 30-day. So if a parolee is facing a 30-day revocation, but they're sitting in a combined time between jail and then the time they're sitting in DOC, they were sitting anywhere from 60 to 90 days, which, again, our measurement is if that's a swift, certain, and proportional sanction, that's going beyond, I think, what the sanction was intending, specifically for the parolee system. But in order to, the intent originally was keep the systems the same, so our recommendation at the time was to make the same changes for both probation and parole. And so, but we're going to, we've been working with stakeholders to have a recommendation for that. So the proposed resolution for this is to authorize the Division of Parole and Probation to impose jail sanctions or electronic monitoring as an intermediate sanction before they get to those longer temporary revocations. Again, if the response to supervision is to have that swift, certain, and proportional sanction, having a quick jail sanction, in other states they refer to these as flash incarcerations or DIPs, in order to quickly respond to an issue would help the division be able to manage the caseload of those. It also allows the person being supervised more opportunities. They're less likely to lose their job if they're only serving a couple days here and there in jail, or if they're on electronic monitoring, they're less likely to lose their home. And so we're setting them up for success as well when it comes to being on supervision. So this is what that adds. It adds an intermediate sanction. And so revising this section would require the Division of Parole and Probation, would authorize them to be able to do that, and then require them to incorporate it into their graduated sanctions and their matrix, and have a policy for that. And then in order to do that, then what we recommended specifically for the parolees was to get rid of that 30-day temporary revocation, because that's not what's happening. If the first temporary revocation is 90 days, that actually does codify what the data shows us is already happening for parolees. And so there's just no way for a parolee to serve a 30-day temporary revocation in our current system, because they have to be returned to the Department of Corrections, and they have to be housed in jail before they're transferred to the Department of Corrections. And so by removing that 30-day, it just codifies what's already happening. The amendment that's been that we've been working on, that I have got that I'm going to bring to the committee, is going to be to leave the 30 days for the probationers, because right now our qualitative data shows that that might be working for the probationers, and we don't have that data because I need to get that from the courts, which I don't have that data yet. So our data doesn't support that recommendation. I guess it could support it if we wanted to treat them similarly, but probationers and parolees are different, and so it does make sense to supervise them different and give them different opportunities because of where they're at in the criminal justice system. So again, the recommendation on a very high level, if you look at 4 and 7, and then 5 and 8, would be to authorize the Division of Parole and Probation to have intermediate sanctions where they can impose jail time of 1 to 10 days in the aggregate of 30 days before they get to those temporary revocations. They will be exhausting their other sanctions before they get to that. And then for parolees, leave it so that it's 30, 90, and 180 days, which is not in the bill right now, but would be our amendment to propose. And then for parolees, it would go from 90, 180, and then a full revocation on the third. And then, let me just make sure where we're at. Oh, and then sections, let's see. Sections, 4 and 7 also revise the definition of technical violation. So what the definition here, if you, so in 4 and 7, so again, appropriate for parolees and probationers, would be to revise that definition to exempt certain conditions related specifically to sex offenders. So what happened when AB 236, when the definition was developed, was it did not address sex offenders. And sex offenders operate under a different statutory scheme. All of their conditions are laid out. And so what we needed to do was distinguish what is a technical violation and what's a non-technical violation. So this definition is a little tricky to read because, again, the technical violation is what's not, but then there's another negative in there. And so the proposed language here says a violation of a condition required pursuant to 176A 410 other than a violation of those. So the paragraphs you see listed here, those are technicals. So reading and the definition, anything that's not listed is a technical. And I can summarize those real quickly because I have those sections listed. So these are not, the ones I'm going to read are technicals based on this corresponding NRS section. So there are certain requirements for your residency, that would be a technical. Abiding by a curfew, that would be a technical. Submitting to tests as required by the division, specifically to substances, that would be a technical. Again, abstaining from alcohol would be a technical. And then complying with the use of medication, if they weren't complying with that, that would be a technical. We do have two other recommendations in our amendment that we're going to propose, would be also not the condition to not use aliases or fictitious names, that would be a technical. And to not obtain a post office box, that would be a technical. And that came from a few agencies as far as how that looks on the ground right now, and we can talk more about that. But just so you have an idea of what would be a technical and what would be. The types of conditions that would not be a technical, these would not be technicals, would be accepting certain types of employment or volunteer positions without approval by their officer, submitting to a polygraph test if they were to not, that would not be a technical, not having contact with the victim, should not be a technical. Not having contact with certain age persons would not be a technical. And then being within certain places where children are, right, those limitations, if they were to violate that, that would not be a technical. Not possessing certain explicit material, not having a device that's capable of, it says accessing the internet is what's here, so that would not be a technical. Being in a business with certain types of entertainment would not be a technical. And then not providing certain information about their enrollment, it looks like in a program. So those would not be technicals. The other thing that is in here that changes the definition of technical violation would be, it says here, termination from a program which provides residential treatment. So if a person were participating in a residential program and they walk away from that program, which is they abandon it, then this, by putting this in here, this makes it not a technical. Because right now that is a technical. When they're supposed to be participating in a residential program and they've chosen not to participate and they walk away, by putting it in here, in this way, it makes it so it's not a technical. And then the last thing that I'll just mention, which I have up here, is just the amendments that we're already working on. As I mentioned, adding those additional conditions from the sex offender section so that those would be technicals, by adding them to the definition would make them technicals. Again, leaving the 30-day temporary revocation for just probationers, but not for parolees. The other thing that came up was requiring the judge and the parole board to apply credit for time served for any time they're sitting there waiting for their hearing. That's not in statute right now, but this would just, qualitatively, it sounds like that might be happening in practice, but this would ensure that any time that they're sitting waiting for the outcome of their hearing, they're getting that credit time towards their temporary revocation. The other recommendation here for an amendment would be to have a finding from both the judge and the parole board that the graduated sanctions have been exhausted, so that we're tying that together. And then, like I said, adding those conditions. For both the parolees and probationers. And then the other recommendations I have for an amendment would be related to those sections that revise our statutes. So one of the things that's come up in our data collection is the concern about confidentiality. So we'd be requesting an amendment to ensure that data we collect remains confidential and is not subject to certain requests. And then, as Mr. Pirro mentioned, AB 236 created the Nevada Local Justice Reinvestment Coordinating Council, and that's a council, a coordinating council at the state level. And one of the things they need is authorization to accept certain types of grants. And so this amendment would authorize them to do that, so we can do some of the work in other counties that Mr. Pirro has mentioned. So with that, concludes my walkthrough of the bill. And I've got other partners from the other criminal justice agencies to answer questions.
Thank you so much for that, Ms. Gonzalez. And you keep referencing amendments that will be submitted, which is great, because we always appreciate knowing when we consider those friendly amendments, that when the bill sponsor is accepting or creating / developing the amendments themselves. As we know, for new members especially, amendments can come from anywhere, but we appreciate knowing when the sponsor is part of that or accepting it. So can you just give us an idea of when we can expect those amendments to be submitted?
For the record, Victoria Gonzalez, yeah, I can get those to you in the next day or two, and it'll be a report where I'll have an outline of each amendment and then the proposed language and everything we want to put in there.
Excellent, thank you. We do have a couple questions. The first one will be from Assemblywoman Mosca.
Thank you, Chair, and thank you for this detailed information. When it comes to Section 4 and 7, I'm understanding that the problem we're trying to solve is the backup of time. Is it recent? Is it a trend? Is it because we're now collecting the data, and has it been updated in the past?
Victoria Gonzalez for the record. So I just want to make sure I understand the question. You're just wondering if that length of stay is still longer than 30 days?
Thank you, Chair. The question would be I'm trying to understand if this is a recent issue because now we have more issues that are leading to it to be larger, or if it's been a long-term trend, or you'd mentioned that now we're collecting the data. So just trying to understand the origins.
Of the origins of, I'm sorry, just to be sure, I just want to make sure I answer your question.
The origins of why we're now considering changing the timelines.
Got it. So Victoria Gonzalez for the record. So AB 236 went into effect July 1, 2020. And so this would be, we didn't have the data before to really understand, what was happening. I knew anecdotally there was an issue. And so the criminal justice agencies and I got together and realized that we wanted to make sure we had a data-driven recommendation. And so that's the only reason. And because we were still getting our feet under us to figure out how to get data. And so, and now that we've got a handle on that, we can. But then when we go back to the data, we can see that this has been the issue the whole time. And again, it's because of that statutory structure for parolees. There's no way to make that shorter unless that structure or something is changed on how a parolee has to be transferred back to DOC. But that's how, does that answer your question? Okay, great.
Thank you for the question. Thank you for that response. Our next question is from Assemblyman Urick.
Thank you, Chair, and thank you so much for the detailed presentation. I will tell you, even as a trained attorney, I find that statute, particularly with 4 and 7, difficult to read. I was up last night trying to do the negatives and figure it all out. So I guess what I would like to do is just kind of clarify something, and then if you can also, then I'll ask my question. And I appreciate your effort to go through and identify the specifics, and specifically for sexual offenders that are on probation or on parole, that we now want to include in the definition of non-technical violation. That would include the termination from an inpatient program. It would include failing to comply with a search clause. And that would be specifically 176A410 sub A. I believe that was listed in the exclusion. So we can clarify. And then, I'm sorry, did you want to jump in?
I can, yeah. So if it's listed there, it is a technical.
Right.
Because A is listed as, Victoria Gonzalez for the record, A is listed in the definition of technical violation, and because there's another negative in there, it actually, so the search and seizure would be a technical, not submitting to that would be a technical.
Okay, and in my understanding of reading it, it looked like it was everything listed there except for these ones. So now we get into double negatives.
I totally agree.
Okay.
So
And we can have legal confirm that as well, too.
Okay, so I guess maybe if we could just get true clarity on those, because I noticed that a number of the ones that I was going to read off were included in the ones that you kind of mentioned earlier as non-technical. I guess what I'm wondering, there's been significant references to the need for database decisions. Can you, or I assume maybe in your supplemental material you'll have that you didn't get a chance to present today, information on the data that led to the selection of these specific provisions that we want to include as non-technical and the reason for that?
So for the record, Victoria Gonzalez, so I'll first just comment. So if it's listed, and we'll have legal, I guess, verify this, but if it's listed here, it is a technical, because there are 2 negatives. So it's everything but then it says a violation of other than. So that other than becomes like that second level of a negative. So if it's listed here, it's a technical. And then to your question about the data, we did not use data to analyze this. The concern was we wanted to make sure to address it because these conditions had not been addressed. It had been discussed that the problem is because nothing was said about these conditions, that makes them all technicals. And so the problem then was what to do with these conditions when they came up. So it was a discussion among stakeholders. The conversation started with the Division of Parole and Probation and the Parole Board. And then at the time, the administration at the governor's office provided insight as well as says, what if we take this approach? And the approach that they had there was from the other side. So we did bring stakeholders together to ask them, what do you think about carving these out? And the question was, do we just wholly exclude these sections, or do we redline and decide what's a technical and what's not? And I do think there's a few ways to address this, but if we don't do something, then all of these are technicals. And the way they're listed is, if they're listed here, it is a technical.
Thank you, and thank you for your question. Our next question is from Assemblywoman Gallant.
Thank you, Chair. My question will not be so technical. Given the fact that we're having staffing issues across the board, and I know with the Department of Public Safety as well, it seems like if this bill were to pass, that you guys are going to need more staff to handle the different programs and ways you would deal with parolees versus, why am I blanking on this? Sorry, probation. So are you guys equipped to handle that? Or if not, how do you plan on addressing that?
Victoria Gonzalez for the record. So I'm not from the Division of Parole and Probation, which we can ask them. My take on this and my conversations with them were this would help alleviate how they're managing that. And so my understanding is they still need their staffing taken care of. And once they have that, they can still handle this. And then from the DOC perspective, they absolutely need help with this because the existing structure they had did not, they're not set up to have these parolees coming back on a regular basis like this. And so this change would help alleviate that so they don't need additional staffing to continue to implement this policy. Let me just check with somebody real quick, see if there's anything else to add.
Thank you for that question, Assemblywoman, and for your response. Next question is from Assemblyman Orlicker.
Thank you, Chair. Thank you, Ms. Gonzalez. It's good to see you in person after being on Zoom with the Sentencing Commission. So I'm glad to hear that the amendments are in the works, and because as we both recall, there were concerns raised at the commission by public defenders to make sure this is a fair approach. So I just want to make sure that the amendments you'll bring forward will address the public defender concerns. Can we count on that?
For the record, Victoria Gonzalez, yes, that amendment that we're going to bring forward to go back to the 30 days for the probationers came from at the recommendation of the public defenders, and we worked through what would make the most sense for them, and so that was developed, and so when that comes through, that will be in partnership with them.
Thank you.
Thank you. Assemblywoman Cohen?
Thank you, Chair, and thank you for the presentation. So I have a question going to back to Section 3 and getting rid of the Nevada risk assessment system and using an appropriate risk assessment tool that the division's going to be administering. Is there going to be any guideline on what that tool is going to be? Is it something that can change frequently based on a whim? Is there, I just want to know if there's going to be, like I said, any kind of guideline so that defense attorneys don't know whether or not they're going to have to be getting to know new guidelines over and over again.
Good morning, Chair and committee members. My name is Aaron Evans, Aaronevans. I'm the Deputy Chief of Northern Command of Parole and Probation. To answer that question, we will continue to use the NRAS system on all of our probationers and parolees that are not sex offenders. The NRAS system was not designed to be used on sex offenders, so we want the authority to be able to use a different tool for that population. As the way this law is written, this says all people on supervision will get an NRAS. So we're just trying to fix the wasted effort of doing an NRAS on that population when we really are doing another assessment on them. but this law says we have to do the NRAS on them. So it's kind of cleaning up that requirement to do an assessment that doesn't pertain to that population when we turn around and do another one that actually does pertain to them. So we're required by statute to do an assessment for their supervision level and their risk level. I certainly don't want to change assessment tools. It's an arduous process, right, to train everybody on a new tool, have it validated, go through all that process. But I think with discussion with Ms. Gonzalez, we have talked about maybe cleaning up some of that language and making it a little more specific to retaining the use of the NRAS, and then some other appropriate language to carve out the other populations that need a separate type of assessment.
Thank you for that. And yes, I do understand that, and I understand how that can be an issue, but I just wanted to get more information about what will be used going forward, who's making that decision, if there's going to be one tool that's used, or if is there going to be consistency with the next tool, or is there a possibility that it's going to change frequently? That's what I'm getting at.
Aaron Evans for the Division of Parole and Probation. Our goal is to be consistent so that we can train it consistent, so that we can use it consistently, so that the data that's collected and derived from it can be used appropriately. So if we develop, and we currently use a tool called a VASOR 2 for our sex offender population, that's what we would use, and that's what we would use statewide as a validated tool. Should issues come up with the tool in the future, then obviously we'd look into replacing it, but it would be standardized across the state.
Okay, thank you. And thank you for that. That concludes our questions for now. So I'm going to open it up to testimony. So I will say the phone number right now because I know that everyone here in Carson City understands that they may approach if they're intending to testify in support of Assembly Bill 32. The phone number for the public that's listening, the number is 1-669-900-6833. And the meeting ID is 821-606-59678. So if there's anyone here in Carson City that would like to testify in support of Assembly Bill 32, please approach. And everyone will have up to 2 minutes for their testimony. And please remember to state your name and spell it for the record, please.
Good morning, Chair Miller and members of the committee. My name is Jennifer Noble. I am testifying in support of this bill today on behalf of the Nevada District Attorneys Association. But I also come to you today as a chief in the Washoe County District Attorney's Office who knows very well what it feels like when you make a suggestion to Ms. Gonzalez or challenge one of the recommendations of the Sentencing Commission, and she looks at you and says, that's not what the data says. And that is a humbling feeling, but it's also something that gives me gratitude for the work that she is doing and that this commission has done in providing evidence-based, data-driven recommendations that will benefit our entire criminal justice system. We're in support. Thank you.
Thank you, Ms. Noble.
Morning, still morning. My name is James Palumbo, Palombo, and I represent the Nevada Prison Education Project. I want to sort of introduce that project at this moment because your group and some other people here, we cross-reference some concerns in terms of reentry and recidivism and reducing public harm. And so I hope that people will reach out to us in the context of their continuing work or your continuing work. And then, and a second piece to this is I would, as I did with the Senate Bill 103, I would like to recommend that an ex-offender be on the Sentencing Commission. I've been part of commissions for 4 decades, and that's always a valuable asset to have in terms of what's produced. So I'm making that suggestion. That's it, and thanks for the consideration.
Thank you so much. And sir, did you sign in by any chance? Okay, so great. So then your name and contact information is available for members to reach out to you. Yes, to learn more about your program. Anyone else here in Carson City? Anyone in Las Vegas that would like to testify in support of Assembly Bill 32? Not seeing anyone in Las Vegas. Broadcasting, please open the lines.
If you would like to provide testimony in support of Assembly Bill 83, please press star 9 now to take your place in the queue. Chair, the line is open and working. There are no callers wishing to participate at this time.
Okay, thank you. Then I will open it up for testimony for anyone in opposition of Assembly Bill 32. We'll start here in Carson City. Please proceed.
Good morning, Chair. John Piro for the record, JOHN-PIRO. We are in opposition only to the bill as written. We have been working with Director Gonzalez to find solutions. One of the things that I do want to bring to the committee's attention, just the particular parts that we are particularly in opposition with. We agree that the intent that she's seeking to do is fix the process for parolees. We're wholly on board with that. We happen to feel that parolees are a little bit differently situated than probationers. So the change to the probation stuff in Section 4, subsection 3A and 3A in particular is what we have the issues with. One of the things that we have an issue with is the flash incarceration, and I think we can work something out there. And one of the main reasons I have that issue with that is in October 21st, 2022, our office and the courts got a letter from the Southern Command of the Nevada Department of Public Safety, and I can provide that letter to the committee. It took a while to get my hands back on it. But in short part, it said, in June of this year, the division became aware of misconduct by one of our former employees. The division learned that this person neglected their caseload and deactivated cases, and in some cases, the offenders were told that they were no longer on supervision. So with the flash incarceration part, there's due process concerns that would maybe not bring us into the picture, but I think we can fix that. One of the things and the reasons that it's good that we're in the picture right away on a technical violation is when somebody's put in through the CJCC, Clark has been really good at getting the hearings within 15 days for a probation violation. And we're then brought into the process and we're getting the people services that they may not have gotten at the start of probation, or we've noticed an increase in the need for services and we're putting them back on the right path. So we do not want to change the provisions in probation that AB 236 did. So that's one of our main objections. We're fine with the electronic monitoring part. But we do not want to change what AB 236 fixed. We can discuss some of the things as far as technical violations. Director Gonzalez brought up like aliases. Well, I don't know that I want to make that a technical violation for some people. To some people, I'm known as Piro. To some people, I'm known as John. To people I went to trial lawyer college with, they call me Johnny Vegas. Those could all be aliases. I don't
Mr.
want to get in
Vegas,
trouble.
thank you.
Thank you, Chair. Erica Roth on behalf of the Washoe County Public Defender's Office. I will echo those sentiments and just thank Executive Director Gonzalez for reaching out and working with all stakeholders. And so I do think we can come to an agreement. Thank you.
Thank you.
Good morning. I'm Beth Schmidt, BETHSCHMIDT, from the Las Vegas Metropolitan Police Department. We are opposed to AB 32 as it has been introduced, but we are working with the Executive Director Gonzalez. We are hopeful to get to a position of support. And one of the things we do appreciate is the ongoing dialogue reference this data-driven recommendations. And just for the record, the Clark County Detention Center does fall under the Las Vegas Metropolitan Police Department. So we look forward to continuing that work.
Thank you.
Good morning, Chair. Good morning, members of the committee. I am Jason Walker, JASONWALKER. I work for the Washoe County Sheriff's Office, and I am currently testifying in opposition as introduced as well. Given some unknown impacts to our detention facility, again, I have spoken with the bill sponsor, and with some language change, we are hopeful to get to a position of support.
Thank you for your testimony. We'll go to Las Vegas right now. Is there anyone in Las Vegas that would like to testify in opposition to Assembly Bill 32? Not seeing anyone in Las Vegas. Broadcasting, please open the lines.
If you would like to provide opposition to Assembly Bill 32, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to participate at this time.
Okay, thank you. And just wanted to make sure there's no one, is there anyone here left in Carson City that wants to oppose Assembly Bill 32? Okay. With that, I will open it up for anyone that would like to testify in neutral for Assembly Bill 32, beginning here in Carson City. Is there anyone in Las Vegas who would like to testify in neutral? Please proceed.
Morning, Madam Chair.
Good morning.
Good morning. Chris Dorico, Board of Parole Commissioners, DER-ICCO. I'm here to testify in neutral with regard to AB 32. First off, I'd like to commend Director Gonzalez and her staff for all the work that's been put into this. We do speak with her and her staff regularly, and we believe that there's some amendment language that could be included into this, and it appears as all the stakeholders are working directly towards this. I did want to bring up one specific section that hasn't been talked about, and I'm hopeful that maybe there might be able to get some type of language in here to remedy this. And as a part of AB 32, I'm sorry, 236 when it was opposed, and something that might be missing from this bill is when somebody appears back, or pre-AB 236, when they appeared before the parole board, many times if they had less than a year remaining on an alleged parole violation, they would request to just flatten out their time and expire their time and finish their sentence, and not because they did not want to go back out under parole. With technical violations now, the parole board's hands are tied. So if someone comes back and they would just like to expire their prison term, there is no mechanism for them to be able to do so. So essentially, they would come back on technical violations. They would be back out on the streets no longer than 30 days after that hearing. And essentially, we're returning them right back to what they had before, which is many times nothing. No residence, no family, no support. So I would like to work with the director on possible amendment change here that, either to come up with a means to allow individuals who qualify if they want to just expire that prison term in custody, or potentially if they're in for a technical violation, that they not be back out and released to the streets until they have an approved plan by the division. Thank you.
Thank you so much, sir. Is there anyone else there in Las Vegas that would like to testify in neutral? Doesn't appear so. Broadcasting, please open the line for testimony in neutral.
If you would like to testify in neutral for Assembly Bill 32, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to participate at this time.
Thank you so much, Broadcasting. I would also like to make a comment on everyone who testified in negative, that thank you. I appreciate you following the rules, that it's based on its entirety, but I also appreciate the conversations that we've already had, that everyone, all the stakeholders are already working with the sponsor, and that the sponsor has already been receptive and will be submitting amendments. And so we look forward to that. So thank you, everyone. With that, I will go ahead and close the hearing on Assembly Bill 32. Ms. Gonzalez, would you like to make any final remarks?
For the record, Victoria Gonzalez. Thank you, Chair. Just real quickly, obviously, we've all been working really hard on this. I appreciate that everyone's support. It's too bad we can't just have a vote on me, because it sounds like we can all work together, so I love that. But, and then I just wanted to comment on the work with the jail data. Our intent would be to not add more pressure. The hope would be to take some pressure off of everybody with this process. So I anticipate being able to collect that data and include that when it comes to also supporting any amendments that we bring forth. So thank you.
Thank you so much. And I wish we could just vote on you, Ms. Gonzalez, as well. Thank you with that. I will go ahead and close the hearing for Assembly Bill 32. Next up, we have Assembly Bill 83. And Assembly Bill 83 is relating to sentencing, authorizing the modification of sentence of certain prisoners released on parole under certain circumstances. We have Mr. John Pirro is going to present Assembly Bill 83. So, sir, when you are ready, please proceed.
Thank you, Madam Chair. John Pirro from the record from the Clark County Public Defender's Office. As the folks that have been on this committee for quite some time and members of the 2019 legislature will remember, we passed AB 236, which was an omnibus criminal justice bill. It was a huge bill with a lot of pages, and both myself, Mr. Jones, Ms. Nobles, members of law enforcement spent extraordinary amounts of time with each other in the woodshed, hammering out the details of the bill. But sometimes things get missed, and this was one of the things that got missed, and we're trying to rectify that. This was a bipartisan, AB 236 was a bipartisan piece of legislation that has set us on the road to data-driven policy recommendations. The State Board of Parole Commissioners had requested that we move a portion. The intention was to take this portion that's now being added back in and move it out of NRS 176, where it didn't belong, in place it into NRS 213, which, as Director Gonzalez said, that's when we're talking about parole. So move it away from one statute of the one part of the statute and move it into a different. But also add a requirement of early discharge of parolees that mirrors the one for early discharge of probationers, but with some clarifications. Section 1 of this bill will authorize the State Board of Parole Commissioners to petition the court to modify a person's sentence on parole if the person meets certain criteria, and that criteria must include that they've served 1/2 of the period of parole, or having been sentenced to life or have served 10 consecutive years on parole. There are notification requirements that the board must give notice of the petition and hearing to the Attorney General or District Attorney who had jurisdiction of the original proceedings, and it would go before a court, and they would have to find good cause to do it. So it's not an automatic thing, it's just allowing people to petition. And it's just putting something back into the law that was taken out accidentally. We're going to see another bill come before this committee, AB 51, where we're putting something back into law that was accidentally taken out before. And so we're just asking to put this back into law.
Okay, with that, members, do we have any questions? I'll give members a moment. We will first start with Assemblywoman Gallant. Oh, I'm sorry. Assemblyman Urick.
Thank you, Chair. I'm not near as good looking as my colleague over here, so. Thank you, Chair. Thank you, Mr. Pirro, for the brief presentation, as I know we're running out of time. I wasn't here for AB 236, but I'm certainly aware of some of what those intentions were, and I think great intentions to try to bring reforms that are going to help. And I believe it's important to view this bill in the context of those efforts. And I understand it. You said that it looks like maybe some things were inadvertently taken out and we want to put back in. But as I look at this, it looks like in the context of the goals of AB 236 were to reduce sentencing guidelines before incarceration. We were looking to reduce the length of incarceration. We were looking to reduce incarceration at all for nonviolent crimes. And as I understand it, looks like this bill ostensibly wants to go a little bit further by now modifying a sentence of a person who, even after all of those reforms, was tried and convicted, was sentenced to prison, and has presumably exhausted all of their potential appeals by now modifying or reducing the sentence that was imposed in some cases by years or even decades. So I guess my question is, what are we proposing to accomplish with this bill? Is it because of an overburdened system and we're looking to lighten that? Or is there reason to believe that these efforts are going to reduce recidivism?
John Peel for the record. I would just say it's giving people a chance to petition. You are absolutely correct, Assemblyman, that if they have served their time on parole, so they've done their prison sentence, they're doing parole, but if things are going well, it just gives them a chance to petition to reduce the length of parole. But that's, again, with their parole officer's blessing that this even go before the court, or if, let's say, a defense attorney puts that before the court, it's still going to have a hearing in front of a judge with the DA or the Attorney General able to weigh in. So I would say that. I would say, and I don't want to speak for parole and probation, if there's people that are even more overburdened than us, it's them.
Thank you for the question. Thank you, Mr. Pirro. Our next question is from Assemblywoman Gallant.
Thank you, Madam Chair. It seems, I was looking at it with the life imprisonment. I'm curious about how many crimes happen that are nonviolent or non-sexual that would elicit a sentencing of life imprisonment.
Jump here for the record. Off the top of my head, I can only think of one, and perhaps Ms. Thornton may be best to answer that. I can only think of like drug trafficking, like large level drug trafficking, off the top of my head. But I agree that those are ones. And you never get off, as far as sex offenses go, to use your concern, you never get off lifetime supervision. That's not a thing where you will ever be able to get off or get yourself off that. But to clarify, and even a lot of attorneys from my office get confused, probation, parole, separate from lifetime supervision, two different things, right? So you will always be on supervision as lifetime supervision if you commit a sexual offense. That's not something you're going to be getting off of.
Thank you for the question. Next question from Assemblywoman Summers Armstrong.
Thank you, Madam Chair, and thank you, Mr. Pirro, for your presentation. In number 6, section 2, number 6, it lists risk and needs assessment, means a validated, standardized, whatever that word is, tool that identifies risk factors. There was a change that was suggested in the previous bill. Does that need to be meshed together so that there's clarity about whether the assessment is, I think the term was appropriate? Does that need to be fixed here so that these are talking to one another in the same language?
John Pirro for the record, probably parole and probation may be the best agency to answer that question since they're the ones that do those assessments.
Thank you, Assemblywoman. Assemblyman Gray?
Thank you, Madam Chair. Just a quick clarification. For the way I just want to make sure I'm reading this right. I'm not an attorney, so you've got somebody who received a lifetime sentence. They were granted mercy and then put on parole, and now they can be taken off parole and be clear of supervision and parole?
John Pirro for the record, they can petition for it. It's permissive. So they could if everybody agrees. If everybody doesn't agree, no.
Thank you.
Thank you, Assemblyman. I don't see any additional questions from members. So with that, I will go ahead and open it up for testimony in support of Assembly Bill 83. Again, if you are here in Carson City, please approach. Anyone in Las Vegas wishing to testify in support of Assembly Bill 83, please approach. Broadcasting, please open the lines. And again, our phone number is 1-669-900-6833. Meeting ID is 821-606-59678. Broadcasting, is there anyone wishing to testify in support of Assembly Bill 83?
If you would like to testify in support of Assembly Bill 83, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to participate at this time.
Okay, thank you. With that, I will open it up for testimony for for those wishing to testify in opposition to Assembly Bill 83.
Thank you, Chair Miller, members of the Assembly Judiciary Committee. My name is John Jones, and I'm here on behalf of the Nevada District Attorneys Association. And I do need to start off by apologizing to you, Chair Miller. I did get my notice of my concerns with the bill to you a little late, and I do apologize for that, and I promise to do better in the future. I want to start off by saying that sentences are a reflection of how the trial judge or jury viewed the case at the time the case was heard. And they determined what they considered to be the most appropriate punishment. And I'll note that case law is pretty clear that both the state and victims deserve finality in sentences. And that's something that I cannot stress enough. There are not many procedural vehicles to challenge the implementation of a sentence after it has been imposed. I'd also like to point out that there are no standards in this bill in what circumstances either the NDOC or the parole board should consider sending this motion to the courts. There's no standard as to what a judge may consider when deciding this motion. I also want to point out that when we're talking about life tales, we're talking about murder cases, sex assaults, lewdnesses with a minor, cases where a judge has considered all of this evidence and determined that somebody should be on a parole their entire lives. I will note that I think in the previous bill we heard that parolees are different than probationers, and I think that applies to this bill as well. And finally, there are no mechanisms by which the NDOC or parole board could notify the victim. As I testified when I presented in front of this committee, it is everybody's job to notify victims pursuant to Marcy's Law. And in this instance, if you guys are to consider and pass this, the parole board or NDOC should be charged with notifying the victims that this is being requested. Thank you, Chair Miller. If I may, just one thing. I do plan on working with Mr. Pirro to see if we can come to an agreement. We did speak briefly prior to this hearing, and we'll continue those discussions. Thank you.
Absolutely. Thank you. I appreciate that. Anyone else here in Carson City in opposition? Anyone in Las Vegas that would like to testify in opposition for Assembly Bill 83? Broadcasting, do we have anyone on the line in opposition?
If you would like to provide testimony in opposition to Assembly Bill 83, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to provide testimony at this time.
Okay, thank you. Then with that, Mr. Pirro, would you like to make any final comments? Oh, after people testify in neutral, just giving you a heads up. So is there anyone in the room that would like to testify in neutral?
Good morning, Chair and members of the committee.
Testify in
I apologize. Is it my turn?
No, you are correct. We're going to start in Carson City first, okay, broadcasting? Please proceed.
Good morning again. Aaron Evans, Deputy Chief for the Division of Parole and Probation, Northern Command. I want to give, first let me answer Assemblywoman Summers Armstrong's question about the risk and need assessment. I think that's a definition. In that other bill, NRAS is defined as a risk and needs assessment. The language that was going to change was just changing it to the appropriate risk and needs assessment. So we don't feel that there's any need to marry up the language. When this section of law was removed in AB 236, it changed the path for somebody on a life term of parole to get some sort of sentence modification or commutation. And what happened when this part of the law went away, their only relief was through the pardon process. As a division, we complete the pardons investigation reports that go to the pardons board, and we adapted procedures to add commutations into that process. It's not quite a sentence modification. I think it's I don't know, I'm not an attorney, but I think it's like a commutation would be a step up from a sentence modification, but it would still allow them to get off of life parole. In that pardons process, our investigators do a very in-depth investigation of that individual that covers the minute that they've got out of prison and what they've done since. You know, their personal life, professional lives, their record on supervision, how the victims feel about them potentially getting a pardon or commutation. We reach out to the judges that may have sentenced this person to see if they have any input on this. And it's probably, you know, a 20-page report that is then provided to the Pardons Board. And the Pardons Board then hears that case. And the Pardons Board, made up of the governor, the AG, and the Supreme Court justices, they decide if these life parolees should have their sentences commuted, which would let them off of their lifetime tail. So when this language went away, it kind of streamlined the process. It provided a comprehensive report to a board that was able to make a decision as a whole of whether or not these people should be released from supervision.
Can I just ask you, your 2 minutes are up, so to wrap up your testimony?
Yes. Adding this back in there, it says upon recommendation of the division. To Mr. Jones's point, there's no standard of what that means, so the division could just say no to every case. It says the board may petition the original court of jurisdiction, so the parole board could choose to not petition the court. So I just wanted to give those ideas of where it used to be and where it is now. Thank you.
Thank you so much for that. Is there anyone else here in Carson City that would like to testify in neutral? Again, we know the bill sponsor is completely open to working, wrong bill sponsor. That bill sponsor on this side of the room, Mr. Pirro, is open to working with all the stakeholders. Anyone in Las Vegas that would like to testify in neutral?
Thank you, Madam Chair. Chris Tirico, Board of Parole Commissioners. So I want to follow up a little bit here. I'm testifying in neutral with regard to this. I don't think it was really overlooked. We recreated a new statute as a part of AB 236 with regard to early discharges, which is contained in 213.1543. These cases, these lifers, as I'll call them, all of them now, they have the opportunity to be heard before the parole board, as Mr. Evans indicated, and with a very extensive investigation involved. My office houses the executive secretary of the Pardons Board and all the contacts to district attorneys, victims, defense counsel, anybody involved. It's a very good process, and the process has been working, especially with the Pardons Board doubling the amount of their hearings that they conduct each year now. Just a brief little background on this. If it goes back and this language is reinserted to the way it was before, where the Pardons Board was making a recommendation, I really think we're adding a lot of bureaucratic, garbage in here that we don't need. The division needs to make a recommendation, then how it was to the parole board, who would then make a recommendation to the underlying court that heard the case. But how it is now, the division makes a recommendation right to the Pardons Board with an extensive investigation, and a decision is made. I'm not quite sure if we going back to this and putting the parole board back in the middle of this, the division could make that recommendation right to the court itself. So we kind of get thrown into this for like a second recommendation in here, when we have a process now that we only have recommendation to Pardons Board. And so I would say that if, more work could be done there, but really I'm not sure. This is being met right now with the Pardons Board. Thank you.
Thank you for that. And sir, would you like to change your testimony to opposition?
No, this is Chris Tirico again for the record. We're testifying in neutral because there could be some language change in there to potentially remove the parole board from the language that's in the bill now.
Okay, thank you.
Thank you.
Is there anyone else in the room in Las Vegas that would like to testify in neutral? Okay, not seeing anyone. Broadcasting, please open the lines.
If you would like to provide testimony in neutral for Assembly Bill 83, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to participate at this time.
Okay, thank you so much for that. Luckily, I had given our bill sponsor a heads up that I was going to invite him back to make any final comments. So, Mr. Pirro, if you would like to approach.
Thank you, Madam Chair. John Pirro for the record. Once again, I just want to say that it's permissive, so it's not mandatory. None of this has to happen. It just gives the statutory framework that it could happen.
Thank you so much for that. And with that, I will go ahead and close the hearing on Assembly Bill 32. Our last order of business is public comment. So if there's anyone, close the bill hearing on Assembly Bill 83. So if there's anyone here that would like to make public comment, you're welcome to come forward and comment on anything that's under the purview of this committee. Again, we ask that you keep your comments to 2 minutes. So is there anyone here in Carson City that would like to make public comment? Not seeing anyone approach. Is there anyone in Las Vegas that would like to make public comment? Not seeing anyone in Las Vegas. Broadcasting, is there anyone on the line that would like to make public comment?
If you would like to provide public comment, please press star 9 now to take your place in the queue. If you would like to provide public comment, please press star 9 now to take your place in the queue. Chair, the public line is open and working. There are no callers choosing to participate at this time.
Okay, thank you for that. I will go ahead and close public comment. With that, just to let everyone know, tomorrow we will have 2 more bill presentations and we will also have 1 bill hearing. I want to thank everyone for your attention and your excellent questions and for both bill presenters and sponsors bringing those forward. So with that, I will see you all tomorrow at 8 a.m. This meeting is adjourned.